The American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. Senator Mitch McConnell, February 13th, 2016. I don't always agree with Senator McConnell, but I agree with him on that one. This is a violation of our rules, of our history. There have been 13 vacancies within the last 10 months of a presidential election year in American history. 9 of them were before July 1st. Of those 9, 7 were confirmed by the Senate. 2 were not. 1 under President John Tyler, and the other was Merrick Garland. There have been only 4 vacancies in the Supreme Court that have occurred after July 1st of an election year. 0 of them have been confirmed. 3 in 3 cases, including Abraham Lincoln, there weren't even nominees. The president waited until after the election. In 1, there was a nominee. The Senate tabled the nomination. So all of this talk that we've had about history and precedent, those are the facts. 13 in the last 10 months, 9 of them before July 1st, all were confirmed except 1 150 years ago, and Merrick Garland. I agree with Mitch McConnell on the 13th of February, 2016. The American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. He said that 8 months before the election. This confirmation, if it takes place tomorrow, will be 8 days before the election. It doesn't pass the straight-face test. If there's a concern about the will of the American people, about 1/3 of the voters have already voted. This election is already 1/3 over, and yet we're barreling forward with this nomination. We shouldn't even be here. We shouldn't even be having this discussion. One of the reasons we shouldn't be here is that the Judiciary Committee broke its own rules in order to vote this nomination out. Here's Rule 1 under quorum, Section 3 of the Judiciary Committee rules. 7 members of the committee actually present shall constitute a quorum for the purpose of discussing business. 9 members of the committee, including at least 2 members of the minority, shall constitute a quorum for the purpose of transacting business. What an inconvenient rule. But I have to presume that that rule, which has been there for years, was put there for a reason. In order to preserve the tradition of comity and respect for the minority that this body has often stood for. 9 members of the committee, including at least 2 members of the minority, shall constitute a quorum for the purpose of transacting business. That quorum wasn't there when this nomination was reported out. So we've trampled precedent, we've trampled history, we've even trampled the rules. And I know that my colleagues say, but it's in a good cause. We need to get this conservative justice on the court. It's in a good cause. Well, I'm reminded of that wonderful scene in A Man for All Seasons about the ends justifying the means. Roper says, so now you'd give the devil benefit of the law? The rules? Sir Thomas More says, yes, what would you do? Cut a great road through the law to get after the devil? Roper says, I'd cut down every law in England to do that. And then here's the point. This is what More responds. Oh, and when the last law was down and the devil turned round on you, where would you hide, Roper? The law is all being flat. This country's planted thick with laws from coast to coast. Man's laws, not God's. And if you cut them down and you're just the man to do it, do you really think you could stand upright in the winds that would blow then? Yes, I'd give the devil a benefit of the law for my own safety's sake. That's why we have rules, for all of our safety's sake. But we're going to violate those rules. We're in the process of violating those rules. And I've heard a great deal of pearl clutching around here about packing the court. Oh no, somebody's talking about breaking the rules and packing the court. Well, of course, Article 3 of the Constitution doesn't establish how many members of the Supreme Court there should be. The number of people on the Supreme Court has been changed 7 times in our history. It's ranged from 4 to 10. I don't want to pack the court. I don't want to change the number. I don't want to have to do that. But if all of this rule breaking is taking place, what does the majority expect? What do they expect? They expect that they're going to be able to break the rules with impunity, and when the shoe maybe is on the other foot, nothing's going to happen? The people over here are going to just say, oh, well, we can't change these rules. One of the things that's amazed me since I've come here is how people feel that they can do things to one another and never have it have any consequences, never have it come back on them. The shoe may be on the other foot. We don't know what's going to happen next week. Okay. The other piece of this nomination that bothers me in this process is that there's been all this talk about qualifications. I would argue that qualifications aren't the qualification, it's what kind of judge they will be. There are thousands of people in this country who are qualified to be a judge. There are 1,700 federal judges, almost 2,000. There are 30,000 state judges. There are lots of people who are qualified, who've been to law school, who've been to judges, who are smart, who can write opinions. That's not the issue here. The issue is, what kind of judge will this person make? That's what's important. What's their philosophy? This is a lifetime appointment. How are they going to decide important cases? These are important decisions. 1 week after the election, on November 10th, we're going to have an argument in the Supreme Court about the future of the Affordable Care Act. Literally, tens of millions of people's insurance is dependent upon that. Not to mention the requirement in the Affordable Care Act, which is the only legal requirement in the country to protect people with pre-existing conditions. I'm tired of people around here saying, I'm for protecting pre-existing conditions, when they voted to gut the Affordable Care Act 35, 40, 50 times. The President of the United States signs a legal executive order. We're going to protect pre-existing conditions. It means nothing. It's not worth the paper it's printed on. The only way you can protect people with pre-existing conditions is to pass a law that you can do that, and we did it with the Affordable Care Act. If that law is struck down, 130 Americans are at risk. They're at risk. So I want to know, what kind of decisions is this person going to make? The Affordable Care Act is on the chopping block. A woman's right to choose is on the chopping block. The scope of government action, what can we do here in this body, in this Congress, in this government? That's on the chopping block. Election disputes are on the chopping block, and I'm going to talk about a little about that later. But we have this bizarre current practice where we have a so-called hearing, and there are all these questions, and the witness, the prospective judge, says, well, I can't answer that because that might come up when I'm on the court. I can't tell you what I think about any of these things. It's as if you were courting someone, you're thinking about getting married, a lifetime commitment, just like a lifetime appointment to the court, and in the middle of one of your dates you say, well, I really like to travel. Do you like traveling? And she says, well, I don't know. I can't tell you until after we're married. I'm not sure. I couldn't give you a definitive answer to that. And then you say, well, I love opera now. It's my favorite thing to go to opera. How about you? Well, I can't answer that question. I can't tell you because that's a hypothetical, and I'll tell you when you invite me to an opera after we're married. And then you say, well, how about kids? I really want to have a big family. No, I'm sorry, I can't answer that question. That's exactly what goes on in these hearings. Judge Barrett didn't answer much of anything. I can't answer that. I think that's nonsense. She can say, here's how I think about that issue now, but I reserve my right to change my mind in a particular case with particular facts after I've read the briefs and heard the argument. But here's how I think about that now. But no, these hearings are a waste of time. We learned whether or not she did her laundry, but we didn't learn anything about how she's going to decide these cases for the next 30 years. And this isn't something abstract. This is going to affect individual Americans' lives. And yet, we're not allowed to find out what she really believes. But you know what? For these last 3 nominees, the dark money folks have spent about $250 million to put them over the finish line. $250 million has been spent by people, we don't know who they are, to push these nominations. These folks aren't investing that money on spec. They know what they're getting. We may not know what they're getting, but they damn well know what they're getting. They didn't spend $250 million in the hopes that they knew what the results were going to be. They know. They know, but we don't. They're investing. They're not contributing. Okay. We do have some indication of what her philosophy is in the abstract. She won't answer questions about particular cases, but in the abstract, we know she says she's an originalist. She says Antonin Scalia was her mentor. She was his clerk. So she's an originalist. What does that mean? Well, it means if you have a provision of the Constitution, in order to interpret what it means, you look at 2 places. You look at the text, what does it say? And then you look at the intent, the understanding of the text of those 55 men in Philadelphia in 1787. That's it, period. That's the analysis. Well, there's a couple of problems with that. Article 1, Section 8 authorizes the Congress to raise and support an army and a navy. What about the Air Force? What about the Air Force? It doesn't say armed services, it says Army and Navy. So we look to the text, Army, Navy, doesn't mention the Air Force. So let's look at the intent. Do we think that those guys in Philadelphia looked ahead 115 years to the Wright brothers? Of course not. That's ridiculous. That's a ridiculous interpretation. Well, so how do you decide that the Air Force, and more recently the Space Force, is constitutional? Well, you do a reasonable interpretation. What was the broad intent? To protect the country. And therefore, the Air Force and the Space Force are constitutional. But by an originalist standard, neither one passed the test. Not in the text, not in the intent. That's supposed to be the test. It's nonsense. It's a nonsense theory. Then we have provisions. The Air Force is pretty easy, and you know, the president has to be 35. That's easy. There are 2 senators from every state, not 3, not 1, 2. Those are easy. But what about a term like due process? What about due process in the Fifth Amendment? What does that mean in a real case? Can you be thrown in jail for life and not have access to a lawyer? Is that due process? It was for about 150 years. It wasn't until the 60s that right to counsel in the Gideon case became a constitutional right. Did the courts invent that? No, they were trying to put some life into this concept of due process. There's no way to determine exactly what a broad term like due process meant in 1787 or in 1868 or in 2021. It takes a court to think about it and to apply some growth in morality, ethics, law, politics, culture, to put life into a provision like that. You know, there are other ones. Let's see, due process, equal protection of the laws. Equal protection of the laws. It took about 100 years to get from the 14th Amendment to Brown versus Board of Education. So the fact that segregated schools was a violation of equal protection of the law wasn't very obvious in 1868. It took 100 years for us to get to the place where, yes, everybody realizes that that was wrong. And this is one of the fallacies in the originalist theory. And Judge Barrett was asked about this. What about Brown versus Board of Education? What about Loving versus Virginia? I was in law school when Loving was decided. It was illegal in Virginia to have an interracial marriage. It was illegal in a lot of states. I venture to say it was probably illegal everywhere in 1868. But the court in 1967 decided that marriage was a fundamental right. It was something that it was part of the equal protection of the laws. And that it was wrong to tell people of different races that they couldn't marry one another. So, how does the originalists handle that case? They don't dare say Brown was wrongly decided or Loving was wrongly decided. You know what they say? You know what she said? It's a super precedent. Well, come on. That's a label. It doesn't mean anything. That's a dodge. That's intellectual dishonesty. If your theory works, it works. And if you have to say that Brown or Loving or dozens of other cases, Miranda, Gideon, those are all super precedents, it doesn't speak very well for your theory. It's a cop-out. Now, if Antonin Scalia was here, who I knew in law school, by the way, if he was here, I knew him as Nino, if he was here, he would say, well, Angus, if the Constitution needs amending and changing, you don't do it by the courts, you do it through the amendment process. That's why they wrote it. Well, the problem with that is we'd be amending the Constitution about every 2 weeks around here. Can you imagine if we had to do an amendment to the Constitution with going through Congress by 2/3 and 3/4 of the states to legalize the Air Force? Or say that due process means that you don't have to give evidence against yourself, that you have a right to a lawyer, that you have a right to be told what your rights are, as is the case in the Miranda decision. The Space Force, we passed the Space Force last year. We would have to also do a constitutional amendment. No. If that were the case, if we had to do a constitutional amendment every time there's a change in something in the Constitution, in the meaning of a term in the Constitution, the Constitution would be as long as a U.S. code. It just doesn't make sense. The real problem with the originalist theory, and this is Judge Barrett, and I know she's intelligent, capable, law professor, judge, for only 3 years, by the way, but 3 years. The real problem is the originalist theory to which she subscribes, and she says she subscribes to it, allows no room for moral or ethical growth. Everything is frozen in 1787 or 1868 if you're talking about the 14th Amendment. Jefferson got this. Jefferson wasn't one of the framers. He was in France at the time the Constitution was written, but he certainly is one of the founders of the country, the author of the Declaration of Independence, and a successful president. He wrote an interesting letter in 1816 on exactly this point. Exactly this point. And here's what Jefferson said. I'm certainly not an advocate for frequent and untried changes in laws and constitutions. That's the way I feel. But laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, As new discoveries are made, new truths disclosed, and manners and opinions change with the change of circumstances, institutions, that means us, must advance also and keep pace with the times. Listen to this wonderfully. He concludes this. We might as well require a man to wear still the coat which fitted him as a boy, as civilized society to remain ever under the regimen of their barbarous ancestors. Now, I don't think our ancestors, the framers, were barbarous, but they hadn't really thought about things like right to counsel, right to be aware of what your rights were under the Constitution as a criminal defendant. They certainly weren't aware of the awful, awful impacts of racial segregation and racial segregation in the schools. They weren't aware of those things. And Jefferson is right. We have to be able to allow our institutions to change as we become more developed, more enlightened, as new discoveries are made, new truths disclosed, and manners and opinions change with the change of circumstances. Institutions must advance also and keep pace with the times. Now, I understand the problem with judicial legislation. I don't want to convert the Supreme Court into an unelected third branch of the Congress that has lifetime tenure. I get that. The Supreme Court, in its interpretation of the Constitution, can't be totally unmoored from the text of the Constitution or the intent of the framers. But it's got to take a broader view of what these vague terms like due process, equal protection of the laws, privilege and immunities, what those things meant and what they mean today as we've grown and learned. As we've grown and learned. The other piece of this originalist philosophy, and the one that I think may have the greatest effect as it takes root on the current Supreme Court, is not necessarily in the cases that we're talking about like Roe versus Wade. It's more cases like the Affordable Care Act or the Environmental Protection Agency or the FDA or any effort whatsoever around here to do something about climate change. This is a straitjacket for the powers of the federal government. That's really what it's all about. That's why those guys invested $250 million. They want to cripple, strangle, and squeeze the federal government so that it can't act on behalf of the American people. That's what's going on here. They don't like the regulatory state. They want to repeal the New Deal. Some originalists even question Social Security and Medicare beyond the powers of the federal government. That's what's going on here. And yet, they have a narrow, crabbed view of the powers of the federal government, but these originalist folks have a broad view of the powers of the state government to impose on your personal rights. I've always thought of the Constitution as being an elaborate Vegematic which slices up power so that it isn't concentrated in any one place. That's what the Constitution is all about. The fundamental issue of all political science is quis custodes ipsos custodiet. An ancient Roman question. Who will guard the guardians? We create a constitution to give power to people over our lives, and then how do we control them from abusing us? Because history tells us it will always happen. Lord Acton in the 19th century said, power corrupts, and absolute power corrupts absolutely. Power corrupts. And absolute power corrupts absolutely. And the framers knew this. They were geniuses in terms of understanding human nature. So they created this elaborate Rube Goldberg scheme to make it hard to make laws. And boy, did they succeed, as we well know. But even after they created this scheme with 2 houses and vetoes and conference committees and 2/3 and treaties and all of this complex institution, to make laws, they were still scared. They were still afraid of the powers of a rampant majority. They were still afraid of what their government would do to them. So they passed the Bill of Rights. The Bill of Rights. I've always thought of the Bill of Rights as a kind of force field around us as individuals. Things that they can't do to us. They can't take away our freedom of religion. They can't take away our freedom of speech. They can't go after the press. The government can't do these things. But the originalists have a narrow view of what the federal government can do to help us, but they have a broad view of what the states can do to trample on those individual rights. They want to throw us back to a time when every state has its own rules on these fundamental rights. I don't think individual Americans' rights should depend on geography. They shouldn't depend on where they live. Fundamental human rights that are in the jurisprudence of the United States Supreme Court over the last 150, 200 years, they should not be kicked back to the states to be compromised or minimized. Finally, Madam President, what's going on here is an undermining of confidence. We take this whole thing for granted. These magnificent halls, the marble columns, the speeches, the votes. It's all, it's always happened, therefore it always will. No. We're an experiment. We're an experiment that's been going on for a little over 200 years. In human history, we're a blip. We're an anomaly. Democracy is very unusual and very hard. And it depends on trust. If you stop and think about it, it depends on trust. When my town clerk in Brunswick, Maine says, here are the votes, Trump 87, Biden 104, I trust that those are the right numbers. I trust. And if I don't, then that way lies chaos. And what this Senate is doing right now is undermining it's one more drip in the undermining of confidence in this institution. It's no secret that confidence in Congress has plummeted over the last 25 or 30 years. And we're doing it. We're adding one more brick to that wall of lack of confidence in this process by violating our history and our rules to barrel through to a confirmation that I think is inconsistent with the rules and principles of this body and our own personal obligations. This is a blow to the Senate. What this process says is anything goes as long as you have the votes. We don't care about the rules of the Judiciary Committee. We don't care about the history and traditions of the Senate. If you got the votes, ram it through. This body is built on some restraint, on some rules of comity and restraint and responsibility and thinking of what happens next. You're going to win this. You got the votes. You're going to put this judge through. But at the cost of just pulling one more support out of the edifice, out from underneath the edifice of this magnificent government. It's not only a blow to this institution, it's a blow to the court. It's a blow to the court, and here's why. Here's why. Of all the things that Judge Barrett said and didn't say in her hearing, the one that disturbed me the most was her failure to commit to recusing herself if a matter comes before the court shortly after her confirmation involving this election of her patron, Donald J. Trump. That's a gimme. You know why? Because all the court has is its credibility. The court doesn't have an army. It doesn't have the power of the purse. All it's got is its integrity, its reputation for fairness. It says, if you go out that door and look up, it says, equal justice under law. That's what it's all about. The judicial canons speak to this issue very directly. Often in our lives, we all want to avoid impropriety. But the judicial canons go even further. 2A of the judicial canon says a judge must avoid the appearance of impropriety. What could appear to be more improper than a judge appointed by a president of the United States, and 10 days later she votes on a matter that will involve his election? He has already told us he wants this election to go to the Supreme Court, and he's already told us he wants his judge there. That's corruption in real time. That's impropriety right in front of our eyes. That answer alone should have disqualified her. If she didn't have the integrity to say, of course I won't vote on an election matter involving this president, of course I won't, but she didn't. As far as I'm concerned, that's a disqualification. Now, I'm not a Supreme Court justice. I wasn't on the law review. I'm a little country lawyer from Brunswick, Maine, but I know impropriety when I see it. And this is it. This is it. The Constitution is a wonderful document. It has served this country well. The evolution of jurisprudence through the United States Supreme Court, with fits and starts, has generally served this country well. But to put a justice on this court under these procedures, under these circumstances, who we're pretty sure is going to take positions antithetical to those of a majority of Americans, and could take positions that will be profoundly damaging to a majority of Americans, is an abdication of our responsibility. Madam President, I understand that the majority has the votes. I deeply hope that tonight or tomorrow morning, some members of the majority will wake up and have an attack of conscience and say, I can't do this. It's not right. It's not right. I can't sacrifice the reputation of the Senate, compromise the reputation of the Supreme Court, undermine the procedures and history of this body. I can't do it. I hope 4 members of the majority will find it in their hearts and minds to take that position. I'm not optimistic, but I think we all need to go into this decision, and I think all those who vote tomorrow have to understand what they're doing and what it means and what it will mean to the people of this country. Madam President, we could have done better. We should have done better. We owe it to the American people to do better than this. Thank you, Madam President. I yield the floor.